Good afternoon, and welcome to our third presentation in our Doing the Work series, Systemic Barriers to Social Change and Civic Participation. My name is Kenitra Brown. I am the staff attorney at the Deason Criminal Justice Reform Center, housed at the SMU Dedman School of Law. I, along with my co-host, Erica Fidel, Director of Diversity and Inclusion at the SMU Dedman School of Law, curated this series to help provide thoughtful and crucial context around the national conversations about race and social justice. I'd like to remind everyone that we are recording this presentation. We have a very full panel today, so if you have any questions, we'll be monitoring the Q&A, and some of our wonderful panelists have agreed to stay on the webinar for about 15 minutes after our official end time for additional questions and commentary. We have a content-heavy program today, so I'll keep our introduction short. The Deason Center was established in the law school in 2017 under the direction of Professor Pamela Metzger. The center brings a stats and stories approach to criminal justice reform. We use stats to emphasize the stories of real lived experiences of justice-involved people to make compelling cases for criminal justice reform. We tell these stories through research, education, and advocacy. While our primary areas of research concern prosecutorial discretion, public defense, and small tribal and rural justice, our engagement agenda recognizes that we don't and can't do our work in a vacuum. And so it includes conversations about salient justice issues in the national conversations and hopes to provide context about the critical intersections of institutions in the arc towards justice. Today's panel is here to do just that. I'd like to briefly introduce our esteemed moderator, Professor Jeffery Kahn. Professor Kahn is a professor of law at SMU Dedman School of Law, whose teaching and research focuses on constitutional law and comparative human rights. He will introduce our expert panel and then get this conversation started. Thank you and enjoy.
Thank you, Kenitra. I'm very glad to be here. Today is not quite 2 weeks since the passing of civil rights era icons John Lewis and C.T. Vivian. In the praise and remembrance that followed after their deaths, few paused to emphasize that the beating that John Lewis and many others suffered on the Edmund Pettus Bridge in Selma occurred 9 years after the Supreme Court declared separate to be inherently unequal. And in the decades that followed Bloody Sunday, beatings, shootings, violence, physical and psychological, continued and continues, even as some of the laws and legal doctrines that gave foundation to racism were replaced or struck down. Those violent years, the gradual removal of formal barriers while de facto barriers to equality remain, are examples of the distinction that Dr. Michael Waters made 2 weeks ago in this series between the systemic racism that we seek to eliminate from our society and the functional racism that persists long after the worst and most brazen formal rules are gone. Systemic racism is the racism baked into the system of laws and state institutions. They are the metaphoric foundations on which racism is built. We find it in the Fugitive Slave Clause and the 3/5 Clause and other parts of our Constitution. It is in the state laws that segregated our physical spaces and dehumanize all spaces, physical and otherwise. And it remains in place today. But even when those laws are declared unlawful, after the Reconstruction Amendments, Brown versus Board of Education, after the Civil Rights Acts and Voting Rights Acts, when the law books are sanitized, the racism remains. That is functional racism. After some of the foundations have been reduced to rubble, we still live in that rubble. In the de facto segregated neighborhoods that then affect our school districts, our voting districts, our healthcare. The rubble affects where we build our highways, who works and which jobs, and who has a chance to succeed and rise ahead. The functional racism of this rubble is not cleared away like a new law or overturned judicial opinion. And the rubble makes constructing a better society harder. Nicole Hannah-Jones won the Pulitzer Prize for her essay launching the New York Times 1619 Project, which reconsiders how we teach the history of our country, starting with the arrival that year of the first slave ships. But just this week, Senator Cotton, Republican of Arkansas, launched an effort to strip federal education funds from any school that sought to teach any part of that curriculum. Our past haunts our future, and our present remains a struggle for what that future can be. Today, we discuss civic participation in the midst of this uncleared rubble and the continuing systemic barriers to social change. Please let me introduce our panelists, whose accomplishments and expertise I can only briefly describe before we get started. In alphabetical order, they are Arthur Anthony, who has over 20 years of business litigation experience and is currently a partner at Lock Lord here in Dallas. Arthur has also served the community as president of the J.L. Turner Legal Association, as a board member of the Dallas Bar Association, and as co-chair of his firm's pro bono committee. His legal expertise covers a wide range of complex commercial matters, as well as issues under the Fair Housing Act, voting rights, and state and federal election law. Dr. Candice Bledsoe is a member of the faculty in the Graduate Liberal Studies Department in the Annette Caldwell Simmons School of Education here at SMU, and executive director of the Action Research Center. Her expertise and scholarship focuses on the experiences of students of color at predominantly white institutions, women of color faculty in higher education, and narratives of the underrepresented. Professor Grant Hayden is my colleague here at the SMU Dedman School of Law, where he writes and teaches in the areas of corporate governance, voting rights, and labor law. He clerked on the 10th Circuit Court of Appeals for Judge Danielle Casarez, practiced at the Washington, D.C. firm of Shea and Gardner, and comes to SMU from a full professorship at Hofstra University. Dr. Danielle Casarez Lemi is a postdoctoral fellow at the Tower Center for Political Studies at SMU after receiving her doctorate in political science from the University of California, Riverside. She is a scholar of representation in American politics, with a focus on identity, race, and gender to explore questions of voter behavior and legislative politics. Her research has been supported by the National Science Foundation, the APSA Latino Scholarship Fund, and the Peter G. Peterson Foundation. Last but certainly not least, Professor Anna Offit is also my colleague at the Dedman School of Law. She is a legal scholar and cultural anthropologist with broad interests in prosecutorial ethics, the U.S. jury system, comparative law, and law and society. Her current research is on lay participation in the U.S. legal system. Prior to joining the faculty at SMU, she held fellowships from New York University Law School, the Fulbright Foundation, and Princeton University. So let's begin. And Anna, let me begin with you. Jury service is a civic duty, and one of the few ways that the state's power is controlled by the direct, unmediated power of the community. What are the systemic and functional barriers to its fair and equal operation?
Thank you, Jeff. As Jeff mentioned, my name's Anna Offit. I'm an assistant professor at SMU, also affiliated with the Deason Center. First, I want to thank Jeff for moderating this panel, and also thank Kenitra and Erica for inviting me to serve as a panelist in such distinguished company today. So when we think about civic participation, the right to vote often comes to mind first. But aside from exercising one's right to vote, serving on a jury is the most direct and powerful way that citizens participate in the democratic process. At some point during their lifetimes, nearly 40% of all American citizens will have had the opportunity to be impaneled as a juror. And each year, about 32 million citizens are summoned for jury service. Yet, for much of its history and continuing on to the present day, the American jury system has been an instrument of both systemic and functional racism. This has led legal anthropologists to view the jury system as a sort of miner's canary, signaling, if not also reflecting, deeper inequities within the criminal justice system. Dallas is very much written into the legal history of systemic jury exclusion in the United States. Between 1969 and 1980, a jury selection instruction manual written by John Sparling, who was a top assistant to longtime district attorney Henry Wade, explicitly directed line attorneys in the office to dismiss otherwise eligible jurors based on race. This manual stated that citizens of color could not be fair and impartial, and as a group would only empathize with defendants in criminal cases. For decades, prosecutors in Dallas heeded this advice and did so with the blessing of leaders in their office. They did this by using their allotted number of peremptory challenges or peremptory strikes to identify prospective jurors of color and dismiss them from veneers without any legal need to place rationales for their decisions on record. Though the law changed in 1986 such that dismissing jurors based explicitly on race was no longer permissible in a single trial, the practice of race-based jury exclusion has persisted in Texas and elsewhere. This is where Dr. Michael Waters' comments during the last Deason Center's Equity and Justice in Dallas panel, as well as Jeff's synthesis and metaphor of the rubble of functional racism, are critical to understanding persistent and everyday barriers to citizens' constitutional right to have a voice in the legal system, or to participate in the legal system, in other words, as jurors. Today, jury exclusion has a different face. While my own empirical research suggests that the anti-discrimination law articulated by the Supreme Court in 1986 in the form of the Batson Doctrine has in fact started to deter certain exclusionary practices during the peremptory challenge phase of jury selection, race-based discrimination is alive and well during earlier and more impactful phases of the jury selection process. So first, people of color are functionally excluded from the jury systems for reason of financial hardship. The failure of cities like Dallas to adequately compensate jurors for their service has meant that numerous citizens simply can't afford to come to court for jury duty. Those reporting to the Frank Crowley Courthouse for their first day of jury service will receive $6, and if they drove, actually pay half of that for a parking spot. So this kind of socioeconomic exclusion during jury service has an impact on jury demographics. As we know, as Dr. Waters discussed, Dallas is constituted by racialized communities of poverty, to use his words. Second, people of color are functionally excluded from the jury system during the cause challenge phase of voir dire. So the ostensible purpose of cause challenges, which are exercised by judges, right, not lawyers, is to dismiss jurors who cannot be fair and impartial, often because they harbor bias against a particular party. However, a lawyer or judge's bias about how citizens of color are likely to view evidence or defendants in criminal cases weigh very heavily on these very discretionary decisions. Unlike peremptory strikes, cause challenges are unlimited in number. They're virtually unreviewable. Abuse of discretion is the standard. And though they're instruments of functional exclusion, they're only just beginning to draw the necessary attention of empirical researchers. So let me give just a few concrete examples of how discrimination plays out through these challenges. Jurors are routinely asked, for example, whether they have had previous negative encounters with police officers. They're asked whether they've ever witnessed, been victims to, or been accused personally of having committed a crime. Jurors are asked whether it is their impression that the criminal justice system is stacked against people of color, who disproportionately enter courtrooms as defendants and face incarceration. Jurors are asked whether they participated in Black Lives Matter's protests. They're asked whether they perceive certain laws to be unfair or unfairly applied. So any juror's affirmative response to any one of these questions, depending on the juror's reply and the presiding judge, can be grounds for dismissal. So this, I'd argue, is the rubble of functional discrimination, the perverse result of a criminal justice system plagued with inequity, using accurate knowledge of this inequity as a tool of exclusion itself. So the economic impact of COVID will likely exacerbate some of the problems of jury exclusion I've described, but just very briefly, a recent survey of 650 potential jurors here in Dallas and also in Houston indicated that Black and Hispanic potential jurors summoned to court were more likely to report economic hardships than white prospective jurors. The survey also reveals that Black and Hispanic jurors were more likely than white prospective jurors to work in areas and occupations with increased COVID exposure. But this is nothing new. 20 years ago, the SMU Law Review conducted a joint study with the Dallas Morning News on the demographic makeup of Dallas County jury veneers. And this study reveals that while 40% of Dallas households earned below $35,000 annually, this income bracket represented a mere 13% of those who reported for jury service. So people of color, and particularly Hispanic Dallas residents, were profoundly underrepresented in jury pools. So though the pandemic's impact on the jury system and civic participation more broadly is far from certain, and I'm sure we'll turn to this throughout the panel, state and federal defenders in Dallas have already found themselves hiring jury experts, researchers, drafting fair cross-section challenges based on concerns I've mentioned, all the while recognizing that the postponement of jury service and jury trials for their clients is no solution either. And I will stop there.
Thank you, Anna. Thank you for teeing us off with an important aspect of both systemic and functional racism. Let me now ask Grant with regard to voting in elections, which is another civic duty of direct participation, but one usually occurring on a much larger scale. Grant, can you unpack the different levels at which systemic and functional racism impedes the voice of a truly democratic electorate?
Sure. Thanks for having me on this panel. Thanks to everyone who put it together. All we had to do was show up with a few thoughts. We didn't have to do any of that hard work that Jeff and Erica and Kenitra had to do. Yes, I come to this question of systemic barriers to civic participation through voting rights, which is the legal framework for democratic participation. And I wanted to spend my time trying to briefly lay out 4 basic aspects or facets of the right to vote. And I'll go into a tiny bit of depth on 2 of them. And I'm going to leave the other 2 to Art and Danielle, who are going to have more to say on it. So, as I go through these 4 facets of the right to vote, the thing to try and recognize is that when you're trying to ensure full democratic participation, it's a little bit like trying to keep water coursing through a leaky hose, so that anytime you find a leak and plug it, there are like 4 or 5 other places where the water continues to come out. And so as we step through these 4 aspects of the right to vote, you have to recognize that in order to ensure effective participation, you really have to be paying attention to all of them at once. So the first aspect of the right to vote is just the right to cast a ballot. It's what people think of when they think of voting rights. It's the right to participate. And this right to participate can be impeded in 2 basic ways, and I think Art will talk a little more about them. First, you can have legal structures that just outright keep people, deny people the franchise. And a contemporary example of this would be that many states have felon disenfranchisement laws. Felons are just prohibited from voting. Those laws, of course, were born of race and continue to have massive racial impacts against Black and Hispanic men, mostly in the United States. But that's one way you can limit this first right of participation. The second way to limit this right to participate or cast a ballot, this facet of voting rights, is just to implement structures that make voting more difficult. And the prime example of something along these lines these days are voter identification requirements, which a majority of states have implemented in the last 20 or so years. And the problem with structures that make it more difficult to vote is that those difficulties usually have differential impact against a variety of groups, including the poor, oftentimes racial or ethnic minority groups. And those groups tend to vote in certain ways, and so you're basically keeping those voices out of the political system. So first aspect of the right to vote, the right to cast a ballot, it's the most obvious one. The second aspect of the right to vote, or voting rights, is the right to cast an equally weighted ballot. And this comes up in a couple of different contexts. One context it comes up in is the apportionment context. When the new census numbers come out, those census numbers are used to figure out how many representatives each state gets, which also in turn affects their number of electoral votes. Usually and constitutionally, by the way, this is done according to total population, but I've noticed in the last 2 days or 3 days that President Trump has made noises that he's thinking of excluding undocumented immigrants from that count and using it to apportion. Of course, what that would mean is that states with large numbers of undocumented immigrants would would cost them seats in Congress, and it would cost them electoral votes. So, you know, those states include states like Texas that go Republican, tend to go Republican, right? States like California that tend to go Democratic, and really pure swing states like Florida, all of which have large numbers of undocumented immigrants. And if you were to cut them out of the denominator, would have a great effect on representation. The other context this right to an equally weighted vote comes up in are the districting decisions that get made. And this is where the one person, one vote requirement comes in. For most political districts, we're required to draw the districts to have equal populations. But the issue that comes up is who exactly you're counting. In most situations, we count total population, again, like we did in the apportionment context. But there are moves in various quarters to, instead of using total population, to use maybe voting age population as your apportionment basis, or to use citizen voting age population as your apportionment basis. And what happens when you move like that is you end up, that is, if you use those for your denominator in your apportionment decisions, what happens is it tends to dilute the voting power of certain groups. And Hispanics are the obvious example in this case. Hispanics in the United States tend to be skew young, and they tend to have higher numbers of non-citizens, right, alien residents. And for those two reasons, if you move your bases down to citizen voting age population, you tend to put Hispanics in much larger districts, which numerically dilutes their vote. So that's the second aspect of voting rights, is this right to an equally weighted vote. The third aspect of voting rights is a little bit tricky. It's this right to a qualitatively undiluted vote, which really means that we want to ensure that everyone has an equal opportunity to combine their vote with the votes of like-minded individuals in order to elect a candidate of their choice. And this aspect of the right to vote comes up in districting practices such as at-large districts, and this also covers the gerrymandering situation. So just briefly on these two, when it comes to at-large districting, what at-large or multi-member districting plans mean is that all of everyone in the district votes for every member of their representatives. So if you have 5 representatives, everyone votes for the 5 representatives. And what this means is that if you have a minority in that jurisdiction, even a substantial minority, they're going to find it quite difficult to elect a candidate of their choice because they're going to be outvoted, say 60-40 for all 5 slots. The remedy in those situations is usually to divide up the multi-member or the at-large district into single-member districts. This is something that's going on right now, by the way, in school districts within Dallas County. The Richardson School District just settled the Voting Rights Act case last year, where it agreed to move from at-large districting to largely single-member districting. Frisco, the plaintiffs in the Frisco School District case just survived summary judgment, which means I expect that case to probably settle, I would hope, sometime soon. And it was the same situation. You had largely Asian voters and parents, African-American voters and parents, and Hispanic voters and parents claimed that they were unable to break the lock that white voters had on every member of the Frisco school district. And so that's ongoing litigation. And that's an example of this qualitative vote dilution. And the other example of qualitative vote dilution are the racial gerrymandering cases, which are complicated and we can get into, but certainly Texas is one of the leading states when it comes to fiddling around with racial gerrymanders and diluting Black and Hispanic voting strength that way. One little oddity, I hope this doesn't count too much against my time. One little oddity that pops up in these redistricting cases is that typically the remedy in a districting case is the creation of a majority-minority district, a district where the minority group is now a majority in that district and is able to elect a candidate of their choice. Oddly enough, the combination of the one person, one vote requirement and the fact that we have winner-take-all elections in the United States sets up this weird situation where if you create a majority-minority district, you oftentimes have a minority preferred representative come out of that district. But in order to create that district, you basically have to empty the surrounding districts of those minority voters who are also reliably Democratic voters. And so those districts are more likely then to turn Republican, and it's a well-documented phenomenon. So you know, it's a double-edged sword, and talk about systemic hurdles. I mean, that's a systemic hurdle that's almost dictated by the math of these two features of our system. In any case, the final aspect of the four aspects of voting rights is the slating process. And anyone who's fiddled around with like social choice or game theory or voting mechanism knows that those who control the slating process and those in control of the agenda can oftentimes control outcomes. And certainly Texas has a long history of screwing around with the slating process since most of the white primary cases come out of Texas. And I think Danielle may not be talking about that, but she'll be talking about the slating process a little bit when it comes to her. Anyway, those are the four basic aspects of voting rights and the various ways in which you can fiddle with them and dilute structurally the voting power of racial and ethnic minorities and really virtually anyone else, especially when they're segregated demographically. Now, one final note, what all of these have in common, look, since we're supposed to be looking for a solution, right? Since what all of these have in common in the United States anyway, is we have partisans and elected officials in charge of many aspects of these voting rights and how we structure the electoral system. And that's a problem. And it's a problem because they have the motive and opportunity to dilute the voting power of various racial groups. They have the motive because they know that African Americans overwhelmingly prefer Democratic candidates, right? Hispanics, to a lesser degree, prefer Democratic candidates. Asians used to prefer Republican candidates. Now they're about at the same level when it comes to preferring Democratic candidates as Hispanics in the United States. Whites prefer Republican candidates in about an equal degree, and there are a lot of them. And so for that reason, partisans and people in charge of the election system know that. And because they're in control of the election system, they have the opportunity to exploit that knowledge. And they do so by suppressing the voting on the basis of race. And they do so straightforwardly in some cases, and admittedly in some cases, which is really frightening, especially coming out of North Carolina. In any case, we can't do a whole lot when it comes to the motive. Not in the short run. I think we're not going to see massive shifts in racial preferences when it comes to political party. So we have to do something about the opportunity. And we can do that by tying their hands. And we do that in various ways already through the Voting Rights Act and the Constitution. But we could do it more explicitly by passing some of the new voting rights acts that have made it through Congress in the last year, or two years now. And the other thing you can do is take it completely out of their hands, which is what most European countries do. That is, and some US states, some US states have moved to use nonpartisan districting commissions to do all of their districting. And that effectively takes partisanship and to a great degree, the racial shenanigans that go on with the partisan gerrymanders as well, out of the hands of the people who directly benefit from them. And those have been quite successful so to the extent we can decrease the opportunity for that kind of fiddling, I think that would go a long way to plugging the leaky hose.
Thank you very much, Grant, for that clear description and categorization of the issues involved in this voting system. You spoke in terms of water through a leaky hose. I spoke in terms of foundations and rubble. These are all different metaphors for getting at the problems that we're trying to resolve. So Art, now let me turn to you. What metaphor guides your thoughts? And can you share some examples maybe from your work here in Dallas and elsewhere to protect the vote and how that informs your view of how we should be perceiving systemic and functional racism and the solutions to them?
Thank you. First of all, thanks, Jeff. Thanks for SMU and all of the participants for putting this together. I'm pleased to have this discussion with such an esteemed panel. Look, I come to this discussion as a private commercial litigator in private practice who's made a point to participate in voter engagement and protection of voter rights on a volunteer basis. This period that we're in is a tumultuous period, no doubt, in which our Constitution has been placed under great stress, to put it mildly. Racial and economic inequalities have been laid bare. All of this overlaid in the context of a global pandemic, which has had a disproportionate impact on communities of color. But I come to this and view this moment with a sense of optimism, because taking a broad view of history, I view this moment as yet another cycle and a pattern of advancement and retreat on issues of racial justice that I think lays the groundwork for another period of national renewal. Indeed, I often tell many of my colleagues that this cycle that we're in represents the end of something. Despite the vitriolic rhetoric, despite the division, we're at the end of something, not at the beginning of something else. So we've seen this before. One of the most profound national responses to systemic racism occurred after the Civil War, a period of great convulsion in our national history. And it led to the passage and subsequent ratification of the 13th, 14th, and 15th Amendments, all of which were designed to address these deep issues surrounding race arising from the end of slavery. And the Reconstruction Amendments, at least conceptually, resolved profound questions of citizenship, prioritized the rights of citizenship through federal protection as opposed to state protection, state interference. But that optimistic period during which we saw, for example, the election of more Black representatives in the US Congress from states like Mississippi and South Carolina at that moment than at any other time in our history since, was met with reaction. The average citizen often knows a little bit about the Civil War. The average citizen often knows a little bit about Reconstruction, but we don't talk about really is what scholars call the redemption period, a period of violent systemic reaction that culminated with the Compromise of 1876 in a period of retreat from the theory of Reconstruction and the benefit of Reconstruction from the national government. And this was evidenced by the reimposition of Black codes across the South, the reconvening of state constitutional conventions across the South that stripped away the expansion of the franchise and other advancements in civil rights at the state level. And it led to a more than 80-year period of racial segregation. Then there was a second cycle, which started with the Montgomery campaign. It started with the Birmingham campaign, St. Augustine. It started with convulsions in North Carolina, in Arkansas, and it culminated in the passage of not only the Civil Rights Act of 1964, but the Voting Rights Act of 1965, which formed the pillars of the edifice of civil rights that we enjoy today. One piece of legislation that is often not mentioned as part of this civil rights edifice is the Immigration and Nationality Act of 1965, which deracialized the way we conduct and manage immigration in the country and led to the very broad, momentous, and systemic demographic changes that we've seen over the country in the last 50 years, changes which I think place the United States in a uniquely advantageous position. I know everybody doesn't agree with that. But then there was another period after this opening up of the civil rights period of reaction. It began during the 1980s, some scholars argue, and I think began to start seeing its culmination during Bill Clinton's first term when the Republicans took over the House in 1994. There's a different kind of politics, a politics of division that defined the way political activities were conducted, which culminated in the period, frankly, that we're in today. Some say a marker in that culmination is the 2016 election. But again, I look at this as a period of possible renewal. After the deaths of George Floyd, Fernando Castillo, Breonna Taylor, Ahmaud Arbery, the profound reaction that those events have garnered, overlaid over the profound disruptions caused by a mismanaged pandemic, we're seeing sustained levels of engagement across race, across ethnicity, across age, across sex that we haven't seen in 60 years. So all of this makes me very optimistic about what comes. And I'll stop there.
Thank you very much, Art. That's a helpful framing as well. And let's return to these metaphors, including your metaphor of cycles, to discuss reasons for optimism and reasons for concern. But now let me turn to Danielle and ask for some of your insights. Grant mentioned a lot of aspects of voting, including apportionment and felon disenfranchisement and voter ID. And he also hinted at the issues involved in slating and in candidate selection. So could you add to that framework and talk to us about something that's really essential, but that's occurring before the state often actively gets directly involved?
Yeah, sure. Thank you so much. Hi, everyone. I'm Danielle Lemi. I just want to, again, thank the organizers for putting this panel together. I'm really happy to be here and have this conversation with you all. First, I want to reiterate some of the points that my colleagues have already made about the history of systemic racism in this country. I think it's important to recognize and to highlight the larger context in which barriers to change exist. The United States was imposed by colonizers, and the colonizers erected political systems that are designed to preserve American capitalism and the racism that helps capitalism function. And these systems, they're designed to be oppressive and slow to change because they're meant to preserve the status quo. And so when we talk about representation, there are three problems related to representation. The first problem is that these oppressive systems, they create a desire for marginalized groups, marginalized people to have representation in oppressive institutions. And so when we say we want greater representation, we call this descriptive representation. Candidates or elected officials who resemble marginalized peoples, candidates who look like me, right, look like us. We're asking for a bit of power within a much larger system that exists to preserve capitalism and racism. And so the first problem is representation is not enough for systemic change. And the second problem is one of candidate recruitment and the networks that one needs to have if they want to run for office. Candidates of color, they're often excluded from party networks that come with infrastructure like support and money that help people get into office. And so I will give you a local example. My colleague, my co-author, Dr. Nadia Brown, she's a professor of political science at Purdue University. She and I did a focus group with Black women politicians who are affiliated with the Black Women's Political Action Committee of Texas. We did a focus group with some politicians in Dallas last November. And what we found was that the Democratic Party, for all it says about Black women being the backbone of the party, it's actually very hard for Black women to break into the party network. And in some instances, the party actually excludes Black women by basically neglecting their campaigns in favor of other quote unquote electable candidates. And so representation, it's not always a problem of getting people to run. I see a lot of programs, candidate training programs, those are great to increase the number of people of color running, but it's not always a problem of getting people to run. It's that these institutions, party networks, they're functioning the way they are supposed to function, maintain the status quo by excluding outsiders who are trying to break in and change it. And then the third problem with representation is the problem of the candidates themselves. Just because a candidate looks like me, maybe even has similar experience as me, does not mean they're gonna work to effect radical change. If the candidates we support are status quo oriented and pro-capitalism, we can't really expect them to address the systemic racism that allows capitalism to function. And so I think we need to ask ourselves really hard questions about what exactly we're calling for when we call for increased representation of communities of color. We often assume that just getting more people of color into office is going to create all this change. But how do candidates for office actually help people who bear the brunt of racist capitalist systems if they have incentives to protect capitalist systems and then protect the racism that allows capitalism to function? And those are the questions I think we need to ask ourselves, especially in the city of Dallas, as we have up and coming new politicians. Ask them these difficult questions. Where do you stand on capitalism? What do you think about racism and the racism that's required to make capitalism function? And so those are the three problems that I see with representation. Representation is not enough. Party networks are difficult to break into, and we have a lot of status quo candidates who are really not going to effect radical change once they get elected.
Danielle, thank you very much for those insights and the dilemmas that you pose for breaking into a system that encourages the like-minded to perform and to succeed the most. So now I know that our attendees are very interested to hear from you, Candice, because you're an expert on education. And in many ways, our educational system is the foundation of everything that our society seeks to build, certainly for deliberative jurors, for informed voters, for responsible candidates. So it's that educational system that, although you are the last panelist to speak, really is the focus of so much essential discussion. So what do you draw from our local and national histories of barriers to education and their impacts on these other systems that we've been talking about?
Thank you so much, Jeff, for the introduction. And I would also like to echo my colleagues by saying I really appreciate the Deason Criminal Justice Reform Center for taking the time to organize this esteemed panel. So grateful to be in community with each of the scholars on the call and on the panel today, and to share with you during these times. So I would really like to start with a quote from one of my favorite writers, which is James Baldwin. And the quote is, "Not everything that is faced can be changed, but nothing can be changed until it is faced." And so I'm deeply moved by this quote because it relates to our discussion today, and a great starting point for my remarks as we unpack functional racism and systemic racism, looking at the issues of barriers to education. So to really understand and to have this discussion, we must first consider the historical context about the Black experience in America. Some of my colleagues have talked briefly about this, but I did want to just make sure to address some of the points here to further give us a foundation for this discussion and understanding of these barriers. So since 1619, when Blacks arrived to this country, and they were deemed as property, and henceforth there has been a struggle for Black Americans to have ownership over their bodies and to be seen as human beings versus property. Generations of Black people endured the brutality of slavery, and after Civil War in 1865, we embarked upon this moment called the U.S. Reconstruction. And so during this time, there was a push for certain freedoms for Blacks, including voting and education. However, in 1877, with the federal soldiers who withdrew from the South, we began to see these higher levels of white supremacy in organizations like the Ku Klux Klan that are helping to uphold white supremacy through violence and lynchings. But what we're also starting to see as well are laws and policies that are put into place for every aspect of Black lives. And so we call these laws the Black Codes that were mentioned earlier. These laws prohibited interracial marriages, jobs for Black Americans. They had rules about being home before sundown. And more importantly for this discussion, prohibited Blacks from the right to vote. So Dr. Eddie Glaude, a professor of Africana Studies at Princeton University, he talks about this notion of the value gap. And the value gap is one of America's largest problems is that society values the lives of white people over every other group in America, being Native Americans, Latino Americans, and Black Americans. And because of society's inability to admit to this, there is a distorted vision and our democracy is challenged. Dr. Kennedy, also the author of How to Be an Anti-Racist, he also brings up this concept of the impact of racist policies in America and how these policies and laws have gone on to uphold the infrastructure of racism within this country through various systems. So today I would like to discuss some of the unintended consequences of Brown versus Board of Education 1954. We know that Brown versus Board of Education, it overturns the separate but equal, the 1896 Plessy versus Ferguson case. And this notion that separate and being both separate and equal. But in Black schools during this time of segregation, there was a great deal of cultural wealth. And so it was really a great thing for Black students to have Black teachers and school leaders who were invested in their success and who lived in their communities. And so this decision for the first time affords Black children to access the same educational opportunities as white children, but the unintended consequences are still felt today. And so that once again is the dismissal of highly credentialed Black educators, and as well as other issues as it relates to, as we examine student success in these communities. And so although Brown versus Board of Education was decided in 1954, Dallas schools did not desegregate. And in fact, in 1961, Dallas is one of the largest cities in the South and the last in Texas to maintain a segregated school system. On October the 6th, 1970, Mr. Sam Tasby filed a lawsuit against Dallas ISD, claiming that the school district was continuing to operate within this dual system and a segregated system, which is prohibited from the Brown versus Board of Education. And Judge William Taylor found that Tasby had been a victim of racial prejudice, and he ordered the system-wide desegregation of Dallas schools with deliberate speed. So it's so important that we understand the national history and this history, how this connects to this history within Dallas. I would also like to talk briefly about redlining. Redlining has also had a major impact on education. During segregation, Black people were not allowed to have mortgages on their homes. And so it really affected the ability to have a transfer of wealth to the next generation. But it also routed students to specific schools that were not properly resourced and school districts that were not properly supported. The third aspect that I want to talk about, and it really, I think, goes well with the Deason criminal justice system, is this understanding of not understanding our history and knowing our stories and how that challenges our true democracy. So educational projects, like Jeff talked about early, the 1619 project created by Nicole Hannah-Jones, it really helps to inform us of history and the complexities of functional and systemic racism. And it shows how US slavery is connected to every system in America. So despite its creativity and innovation, as Jeff mentioned, Tom Cotton and others have challenged this project and projects like this that can provide a magnitude of support and curriculum about the struggle of freedom in this nation. So with us not understanding our stories and knowing our stories, it impacts the ability for voters to be informed fully and understand the historical connection to policies and laws today. So stories like Juanita Craft, who was the first Black woman to vote in Dallas County in a public election. And she also helped to organize over 182 branches in the NAACP. She challenged the state fair's Negro Achievement Day, which is the day where the Black community would come to the State Fair of Texas, and she protested that. In addition, after the Brown versus Board of Education, she helped to enroll the first Black student at the University of North Texas. So these are some of the barriers, and once again, the connection to our national history and our local history. And as I've mentioned before, retaining high quality teachers and culturally competent teachers, poverty as well, playing a major issue and impact in education. As we think about children today, it is not uncommon for them to be homeless or hungry, and Dallas is cited as one of the as having one of the highest level of concentrated poverty in this country. So lastly, I would like to talk about the school to prison pipeline. And so as we think about 2 Dallas zip codes in this city that produce more inmates than any other, and that is the South Oak Cliff zip code of 75216 and the Pleasant Grove zip code of 75217. Education and incarceration sadly have been inextricably linked. And so children of incarcerated parents are more likely to experience financial instability, social stigma, post-traumatic stress, low educational attainment rates. And moreover, as we start looking at this connection between education, we're also able to see a connection between graduation rates and crime rates. So when you combine this information, this data, we definitely see how the barriers of education are, in this particular conversation of civic participation and civic engagement. Thank you, Jeff.
Thank you, Candice. That was a whirlwind tour that I wish we had much more time to dive into. We could do an entire panel just on the educational issues that you presented. But now let me bring all the panelists back in and try to frame a question that hopefully will allow us to discuss each one of these different systems: jury systems, the criminal justice system, the educational system, the voting system, but also, as Danielle asked us to do, to challenge some of our assumed premises about the underlying foundations of all of these systems and of our society. And in some of what Danielle said, it struck a slightly pessimistic tone, that perhaps there is something, and I saw in the chat that some of our participants are asking, well, is there some inherent relationship between capitalism and racism? On the other hand, Art struck a slightly more positive and hopeful tone that was noticed in our chat, that these cycles are decreasing in frequency. They're getting closer together. And that might lead to some hope and optimism that we may be reaching a time when the secular nature of the need to keep fighting these battles of different techniques for the same systemic racist ends could come to a close. And Grant and Anna described the wide variety of techniques in jury selection, in the jury system, in the electoral systems that can be used. So let me ask the panelists, is the glass half full? Is the glass half empty? And is the problem the glass itself?
Very, very good question, Jeff. Let me jump in and just skip to my punchline right up front. And I'll say it this way, don't get it twisted. I don't want my sense of optimism to belie the sense of urgency that each and every one of us should have in this current moment. I'm reminded of a quote, I think Dr. King said it, that the hottest places in hell are reserved for those who in a period of moral crisis maintain their neutrality. Nobody, whatever our station in life, nobody can be a fence sitter in this environment. Each and every one of us has to be engaged. But to Danielle's point, my sense of optimism is driven by two things. One, unlike these past cycles, I think one of the things that has distinguished this period in our nation's history is what animates really our current cycle, and that is the profound demographic change that has taken place since the mid-1960s. Change that may be slowed, but change that is inexorably happening. And with that profound demographic change and the prospect of higher levels of political engagement, I think not only can we get to greater representational equity, but I also think that we can shake the foundations of a political system that has historically excluded people of color. Again, in this context, even the language that we use is becoming anachronistic. We were talking earlier about minority and majority. Well, in certain cases, the use of the term racial minority is an anachronism. It already is the case in Texas. It already is the case in California, increasingly Arizona, Nevada. Folks, the country is changing. That's a good thing. And I think it lays the groundwork to shorten a cycle of profound and systemic change in the United States.
Yeah, and I just want to add to what Art is saying. I offered this pessimistic view, but I do think now is the time for a revolution. This is the time, and we need bold leadership now. And we need it especially in a city of Dallas where we're not minorities in Dallas. Black and brown people are the majority in Dallas, and we need bold leadership. And this is the time to tear these systems down.
Let me prod you a little further in this discussion on the same themes. You've often seen, it's almost a bumper sticker sort of expression, act locally, think globally. And we have, and this goes to what you're saying about the anachronistic features of racial minority descriptions. They're anachronistic depending on your scale. And so we can scale locally, we can scale statewide, and we can scale nationally. In the previous generation of progressive fighting for civil rights, it was the federal government that came as a protective force to work against local intrusions and local control. The sort of controls that Danielle mentioned in selecting candidates, the sort of controls that Anna mentioned in the jury manual, and much more pernicious and overt ones. But now we're seeing in Portland, in Seattle, in Chicago, in Albuquerque, an inversion of what many may have come to think of as who comes in to help against whom. On the other hand, we see in other states and localities that the states are now stepping up and becoming leaders. And so is there a general sense of whether the next generation, or our generation, will be primarily one where we're going to be looking towards continued federal assistance in statute form or in the form of institutions like the Department of Justice? Or does the pendulum swing now to looking towards state and local action? Or is that a false distinction?
I'll be very brief. I think it depends, Jeff. I think you're absolutely right that when you look, for example, at the administrations of Ulysses S. Grant, at Eisenhower, at Kennedy, you look at administrations that leveraged federal power to advance racial justice in the particular ways that those administrations were called to do so during their time. To say that the current moment involves an inversion of that, I think has a lot of truth to it. But I often think, again, taking a broad sweep of history, as an African-American man, I often shudder at the thought of where we would be as a nation without a strong national power. and without a strong national power, through constitutional amendment that is empowered to advance civil rights at the state level. And that may depend, how we look at this may depend on which administration is in office, which administration is in office at the state level and at the local level, frankly. But this all is part of our wonderful experiment of federalism that as we continue to evolve as a nation, we'll see slowly brought to perfection. So that's my perspective.
Yeah, and I would just add, in law schools and lawyers generally, we are always looking for kind of neutral principles because we're afraid of actors without constraint. But, I think we put a little too much stock in them sometimes. I think you have to be outcome oriented. I think looking for, is federalism the right principle, because that's going to restrain governmental power? Should we do the opposite? And, all those questions are ultimately going to turn on what it's going to get you in the end. And it drives me crazy when, people are arguing one side or the other and couching them in terms of, as they have in the past, right, states' rights or not states' rights or whatever. It's all going to be situationally dependent. And I think you just have to acknowledge that and go with the route that's gonna get you there. There's all sorts of ridiculousness when it comes to legal concepts and their supposed constraining power. When John Roberts made up out of whole cloth a whole new principle of equal sovereignty of the states to strike down sections 4 and 5 of the effectively strike down section 5 of the Voting Rights Act. That's just it's an over the top and ridiculous example of how malleable these things are. You have to be outcome oriented, and it's going to depend.
In an outcome-oriented world, then, when we look at jury systems, when we look at educational systems, let me ask Anna and Candice, where are you looking for the best solutions and the most leadership?
I think right now in the jury context, we're seeing some interesting experimentation with anti-discrimination law on the part of state courts. Washington State, for the first time, has reimagined the Batson Doctrine from one that requires racial animus towards a more objective standard. So if something could objectively be perceived as racist or discriminatory, that now can support a successful Batson challenge to a peremptory strike that is racist. But the trouble here, I think, more broadly for jury reform is part of what you really have to take issue with, returning, Jeff, to your metaphor, right, the glass itself, right, are the features of the jury system that may not be in the limelight, may not seem so patently egregious, right? Things like as simply, right, in the Northeast, where I've conducted past research, there are questions on jury questionnaires that ask all prospective jurors, do you rent or own your own home, right? Which no one thinks twice about. And you ask prosecutors and defense attorneys about this, and the offhand response is, well, I guess that was placed there decades ago as some sort of indicator of, right, one's investment in the community and so on and so forth. But so clearly, right, as Candice points out, there's the inextricable connection between all of these various systems. We know that, white people in America are more likely to own homes. They're more likely to own vehicles, right, which significantly impacts their ability to drive themselves to participate as jurors or to vote and so on. So I think there is some very essential but more subtle work that needs to go into rethinking the taken for granted, right, the tacit dimensions of structures that may not seem so apparently to create discriminatory outcomes, but clearly do so.
Yes, I would agree definitely with Anna. And, Jeff, as you were posing the question, I was thinking about educational reform during this particular time of COVID, and I really look to the areas of creativity and innovation, But before I get to that, I find it really interesting that before COVID, with different school districts, it was always a problem of, well, we can't get everyone a laptop, or we don't know how to support, how to get Wi-Fi to everyone. But now that COVID is here, COVID-19, we will find a way that make sure that everyone has a device. And now we're doing things that we said that we could not do. And so maybe that goes to Mr. Anthony's point about the end of something and then the beginning of something else. And I think that creativity and innovation plays a major role within that aspect, because I believe that folks who are in these communities, as we've talked about, persons of color, as Dr. Danielle mentioned earlier, they really are change agents. They are individualized change agents who will use creativity and innovation to provide answers and solutions for education reform. So I wanted to say that, and a brief statement about some of the reform that we've talked about here recently as it relates to charter school and private schools, and the effect that that's had on the public education. And so that it really has been, in many ways has many poor public education school districts, and that relationship of charter schools. And so I am hopeful. I think that Paul says that being a prisoner of hope. I am a prisoner of hope, but I'm also one who is willing to go the way. And I think in this particular time, creativity and innovation will play a major role in education reform.
Let me bring us back to concrete problems and solutions. Candice, you mentioned COVID-19, and there's great fear that in addition to the fears that any pandemic would bring, that a pandemic during an election year is something that is particularly pernicious. And in the criminal justice context, that the resort to the sorts of technologies that we are beginning to rely on more and more for our schools and for this very Zoom session, in some ways can be stifling and oppressive if put into a context where immediacy and humanity are so centrally important to the discussion of someone's fate in the criminal justice system. So in those systems, as well as in the educational system, how do you see COVID-19 affecting in the short term? What can be done to eliminate some of the systemic and functional racism that we see, and as opportunities in the long term, as Candice, you pointed out, with the sudden ability of school districts to solve the solvable problems of Wi-Fi and laptops and access to technology.
Okay, I'll take I'll take that question. You know what I was really, when you were talking about that, Jeff, I started thinking about, as you talk about addressing some of the issues in education, but I also thought about the gap, right? And we talk about the gap and how that gap is widening many times as it relates to student success. And for some of the systemic issues that we've talked about briefly, dealing with poverty, dealing with redlining. And so even as we think about those who are affected by COVID, those essential workers, right, their children, they're gonna have a different experience than those who are on this, perhaps who may be on this call today, who can use Zoom and other technology to work from home, right? So those students will definitely have a different experience where I believe in many ways this gap will widen if we don't take the opportunity to address those issues that you talked about. So as it relates to poverty, and we know that so many individuals right now are out of work. And we also know that as it relates to food insecurity and being able to have access to fresh fruits and vegetables, those, as we talk about young people who may be in zip codes where their parents are, or they're living in impoverished situations, there's definitely going to be a gap as we think about those experiences, and it could be a learning gap. So, you know, although this is the opportunity to use creativity and innovation to tackle these issues, there's a lot that's at stake right now. So.
And I think certainly in the criminal justice system, it's a gap that has also become apparent. So recently, it was reported that a third of families in Dallas don't have internet access. So when we talk about a move to virtual proceedings, right, even in the civil system, that presents real issues. We had Judge Emily Miskell very bravely end on YouTube introducing to us what a kind of summary civil jury selection proceeding might look like. But you had many jurors, even in that context, relying on very small cell phone screens to participate. And to the extent I've been spending this summer interviewing prosecutors and defense attorneys about what this might look like in the criminal context, there's very tremendous reservation about not only Sixth Amendment confrontation clause implications that this might have, but also how could you ever conceive of cross-examining a witness through a virtual platform. Though I think for folks who are imagining solutions and thinking about the feasibility of some of these implementations of technology, it's easy to take for granted, as you point out, Jeff, that, well, we're familiar, we're comfortable with these platforms. Surely they can work for others in other contexts. But I think all it takes is spending, morning or afternoon in a courtroom to appreciate how much cannot possibly be captured on a screen in terms of demeanor, intonation, body language, and so on. So I think these are issues that are very worrisome for criminal justice actors right now.
Well, and when it comes to the election system, COVID has mainly manifested itself in a move by many states to mail-in ballots, which seems to have become a partisan fight, despite the fact that I think there's a fair bit of research at this point saying that mail-in ballots do not help either party to any significant degree. Overall, they increase turnout. I guess it's become a partisan fight in part to create chaos and a fear of fraud around the election. And in part, it may be a guess that these are not ordinary times, and perhaps mail-in ballots would help disproportionately people who are affected disproportionately by the COVID virus. And so maybe it's a calculation that there is a racial component to mail-in ballots, but so far we've seen states are all over the map. I mean, Oregon's had mail-in balloting since 1998, no problems, right? Everyone loves it there. And Republican states like Utah now have mail-in balloting. So it shouldn't be a partisan thing. It shouldn't. I don't know that there's a racial dimension that I'm aware of that's been, documented. So I think it's mostly just one more situation where you can stir up fear and cast doubt on election results, which itself is troubling. And I'm not sure the best way to attack those kind of stoking fears that are completely unfounded, right? And that's a whole nother level of chaos.
Yeah, to dovetail on that point, I would just say, the easiest thing for each of us to think about, and everybody that's on this call, is a charge I would issue, and that is to do a few basic things. One, first, register to vote. Make sure that you consult your local county elections administrator's website and ensure that your voter registration is active. Get everyone in your family registered to vote. Get everyone in your network registered to vote. And come up with a plan to actually participate in the elections, both during early voting, if you really can, and certainly by election day, if you can. Texas, if you consult the votetexas.gov website, you'll see that voter registration in Texas now exceeds 16 million registered voters. But turnout never matches the level of registration. I think in order to effect real systemic change, each one of us plays a role in creating a real and enduring culture of political engagement. And that starts where we are. When we register to vote, when we vote, when we get people in our network voting, that gets elected officials' attention, and they respond from a policy standpoint, the way the electorate goes. If you're not voting for whatever reason and you have the opportunity to vote, I submit that you're part of the problem and not the solution. Now, as you participate in the voting process, there are challenges. And that's one of the reasons I and many others through local bar organizations are engaged in efforts to engage citizens in the voting process and to help them vote regular ballots during election time. So register to vote, get everybody to vote, make sure you vote. The second thing I'll say is we think about this in the context of the pandemic, we saw flashes of what can happen in this pandemic during voting in Georgia, in Wisconsin, in a couple of other places. What may become a challenge in Texas, and I think this became true during the recent primary runoffs, is that some counties may have a shortage of election workers. And what that translates into is a shortage in polling stations, which can translate into disenfranchisement, right? So to the extent that you are able and willing, give serious consideration, not only to registering to vote and motivating folks in your circle to vote, but consult the local county administration website and explore becoming a poll worker, because the more poll workers we have out there, the more polling stations that we have, because as things currently stand, given the state of litigation on mail-in balloting, we will likely not have widespread voter mail-in balloting come fall. Now, of course, the election code provides certain categories for folks who can fill out ballot applications and mail them in, but there is controversy surrounding that, litigation surrounding that, different interpretive guidance, even from the AG's office surrounding that. So we have to plan to engage citizens where they are by, if they can vote by mail, vote by mail, but I think for the majority of us, it's going to be in-person voting, and we need physical polling locations. And I would say urge your local officials at the county level to provide real resources, to provide PPE and other resources to frontline poll workers, because we need them on the job. The third thing I'll say, and this is part of what we do, to the extent that anyone in your network has concerns about how they vote, the mechanics of voting, what to do if they show up at a polling station and they're disallowed from voting for some reason. There is a network of attorneys under the umbrella of Election Protection, which is a Lawyers Committee for Civil Rights project that has affiliates across the nation that during early voting and on election day protects the right to vote. You can go to texasvoterprotection.org and get more information about that, or 866-OUR-VOTE.org, and it'll provide all the information you need. But that's where we start. If we can create a real culture at the individual level, at the community level of voter engagement, I think we'll see real change going forward. Thank you.
I just want to add to what my colleagues have said, thinking about COVID-19 and everything that COVID-19 has revealed about what's possible. Now we know that universal basic income is possible. Now we know that it's possible to expand healthcare. Now we know that it's possible to give kids free Wi-Fi. And so to that, I would say we really need to put strong pressure on our state elected officials, state legislators, and our members of Congress. Show up at their offices and demand to have a conversation about the bills they are drafting and how they're voting on those bills. Call them, tie up the phone lines, blast their emails, tell your friends to do it. There's an app called ResistBot where you can program a petition and tell your friends, hey, text this code and it'll sign your name, your address, and send it to your elected official. We need to put pressure on them to vote them out if they are not going to serve our interests. I think this is an opportunity for us to fundamentally rethink the individualist culture of the United States, this pull yourself up by your bootstraps culture, and rethink how we relate to each other. Why are we so individual centric? Why do we believe in meritocracies? We know that meritocracies are not real. And so this is a real chance to like rethink all of the assumptions we have about how the world works. And COVID-19 is showing that when capitalists see that their wealth, their ability to generate profit is threatened, the government will intervene to keep the economy going. And so what we need to do is put pressure on your elected officials. If you are interested and if you feel comfortable, think about what the protesters are saying in the streets. Listen to what they are saying and take their concerns seriously. And also think about all of like what essential workers are dealing with now. We're calling them essential, but we don't pay them enough to live. And so think about the demands that labor unions are making. Think about all of the workplace conditions that your friends might be dealing with. We need to start rethinking this individualist culture in the United States.
Danielle and Art, in your last two responses, you've given us a perfect opportunity to answer one of the questions that are on our list of questions. You've given us, Art, some very concrete steps that can be taken now with regard to our voter system. And Danielle, you've given us some very concrete questions to ask, deeply introspective questions about the fundamentals of what we often take for granted and don't question at all. So in the context of criminal justice and in education and in any system that you choose, let me just ask the entire panel, what concrete steps would you suggest? Whether you find that the problem is with the glass, whether the glass is half full or half empty, but what can someone who's listening to this session do today, tomorrow, and next week with regard to some of the issues that we've been talking about? If as Dr. King said, the arc of the moral universe is long, but it bends towards justice, how do you bend it a little bit right now?
I think in the jury context, the reforms that I would like to see start with compensation for jurors, and there are models for this. In Arizona, for example, there are hardship funds available to jurors who serve to replace lost income up to $300 per day. We know that in the 1960s, the Jury Selection and Service Act was passed. There was a move to change compensation for jurors up that today would translate to hundreds of dollars per day, and yet there has not been any semblance of a commensurate increase in the subsequent years. So what we see is a profound devaluing of civic participation in the context of jurors. And I would even go further to suggest that the jury system itself can be profoundly reimagined to actually help not only those who have income already but are losing income because they're serving as jurors, but to have an opportunity to be propelled beyond present circumstances. Suppose in light of COVID, for example, you are out of work, you're seeking work. Jury service in other countries, and I look to Norway here as a model where I've done research, can be a tremendous credential. You have individuals who participate as jurors not only earning income for doing so, but posting this on their CVs as a credential, using it as a means of gaining work elsewhere. We could imagine a system in this country in which prospective jurors can use jury clerks as references, can really draw on experiences that they've gained in a courtroom as grounds to leverage themselves to a new professional step. So there's absolutely no reason that we can't reimagine our presently constituted jury system as something more like what de Tocqueville observed in saying this could be a source of free education, a schooling for the public. I think the fact that we're not having those conversations has much to do with the fact that jurors are imagined as a transient population. There's so much attention to the resolution of criminal disputes through plea bargaining that we neglect the fact the jury system remains profoundly impactful in lawyers' thinking, their strategic work. Much of the reason, for example, even in this city, that we have policies like prosecutions will not proceed for simple possession of marijuana has less to do with progressive agendas of office leaders than it does with the simple fact that juries have nullified these sorts of cases and prosecutors are reluctant to try them, and leadership does not want to lose these types of cases. So I contend juries are profoundly significant, and that the jury system itself can be reformed to not only better serve our legal system, but to better serve those who are actually participants in that system.
Jeff, if I may, at the risk of beating my dead horse and to dovetail off of what Anna just said, it is not an accident that the United States Constitution touches on voting several times, not only in its core articles, but in at least 4 times in the 27 amendments to the National Constitution. Voting is at the core of who we are. And look, this year marks a confluence of a couple of anniversaries. One, it's the 150th anniversary of the ratification of the 15th Amendment, which prohibited the denial and abridgment of the right to vote on the basis of race. That's 150 years ago. We're also marking the 100th anniversary of the ratification of the 19th Amendment, which prohibited denial of abridgment of the right to vote on the basis of sex. We've been at this a very long time. And to address one of the comments that was raised here recently about voter suppression, there is a reason that part of our cycles of advancement and retreat in terms of voter engagement and citizen participation centers on the right to vote. It is because the right to vote distinguishes us. It distinguishes the character of the nation because we transition power by and large peacefully. Now there's historical context in it, but by and large peacefully by way of the vote. So it is the vote that will drive jury reform. It is the vote that will drive education reform. It is the vote that will drive systemic reform. And John Lewis knew that, C.T. Vivian knew that, Martin King knew that, and many of the warriors that are on the front line today know that. So it is the vote that is at the core of a movement to move the system in a direction that all of us want to see it to be moved. So I would encourage you to exercise that right. It is sacrosanct.
I want to add to what Art's saying is put pressure on your elected officials. And I think it would be productive to have conversations about at-will employment and the fact that your employer can fire you at any time for any reason. And so what does this do? It discourages you from speaking out. It discourages you from saying political things on your social media. It discourages you from going, to the streets to protest anything. It discourages you from advocating for yourself for meaningful change to improve the condition of your life. I also think it's productive to have a conversation about redistribution of wealth. If we're all working just so that we can afford to feed ourselves and have housing, I was just talking to my mom yesterday about this. I'm a millennial. I feel like all I'm doing is just working and constantly looking for work to make sure I have enough money for housing. And that is the center of my existence. If that's all I'm focused on, what time do I have to spend watching what my elected officials are doing or advocating for myself? And so it starts with disrupting capitalism, and it starts with disrupting racist ideologies that we use to dehumanize people, to brand them, specific communities of color, to brand them as essential workers who do all the labor to generate wealth for a few. The two go together.
Well, I think that as much as there is still to talk about, and the issues that we're talking about certainly will not go away, this panel has to conclude at the time that it was set to conclude. But as Kenitra suggested at the beginning, I know that several of the panelists have offered to stay online for a little while longer, but to stay within the formal constraints of our discussion. I think now is the time when I have to and deeply want to say thank you very much to my fellow panelists, to Kenitra Brown and Erica Fidel and Kristen Meeks and the Deason Center for making this possible, and to all the attendees in all of the places that you inhabit who've come together in this virtual way to think with us, to discuss these issues, and hopefully to go out and help to make lasting change. First and foremost by voting, and secondly, and relatedly, by focusing on some of these particular systems that we've discussed today, so that the systems can continue in a progressive way and not in a way that maintains systemic racism. So thank you all very much.